Good morning, everyone. I think this webinar is now open. As I'm sure many of you know, with these things, with Zoom, people are sort of let in from a virtual lobby. So I'm not going to start the talk just yet. I will let people join. So we've got sort of an awkward minute or so while I fill for time whilst people are drifting in. But as you can see from the slide, today's talk is about legal professional privilege. Providing a recap of that. We've got a lot to get through, so we will get started fairly shortly. But I understand that, as I say, people are still coming in. So we'll give it a little bit longer and then we'll get going. But thank you all for joining and welcome to you. I should also say that this webinar is being recorded by us. It will be published on our YouTube channel that we have, amusingly, and a copy of these slides will be circulated afterwards as ever, and also provide my email at the end. Okay, well, we're 1 minute past now. Let's get straight into it. We've got a lot to pack in today, and we may not have time for questions at the end. But like I say, you'll have my email and you'll have the slides and a recording. So between those three things, hopefully that will cover what you need to know. So legal professional privilege is a concept that can be simple in principle, but tricky in practice to apply, as I'm sure many of you know. And as I think most people attending today are solicitors, it's probably a concept that many of you will have more day-to-day experience of than we, the royal we, do as barristers. But today I want to use the relatively recent Court of Appeal decision in Sadeq and Dechert, two words, neither of which I'm quite sure how to pronounce, but use it as a vehicle to discuss and explore three-ish areas of legal professional privilege and use some practical examples. Firstly, I'm going to discuss the iniquity exception. Secondly, very briefly, hence the three-ish, Three Rivers number 5 and its non-application to litigation privilege. And third and finally, but less briefly, the continuing life and application of Three Rivers number 5 to legal advice privilege, including the sort of vexed issues of who is the client and multi-addressee communications. And we'll test these principles by working through some HR and investigation type scenarios in a corporate context, because sometimes it's easiest to actually work through practical scenarios to test the limits and the boundaries of privilege. As I'm sure you'll appreciate, but just to be clear, this talk is not about without prejudice privilege. That's a different aspect to the law of privilege. My colleague Doug Cochran did a talk on that, on the WP rule in, I think, April of this year for this seminar series. So that's available on the website if you're interested. So between the two of us, I think we've covered hopefully most of the privilege this year. But let's get going with Sadeq. So this was a judgment of the Court of Appeal handed down in 2024. The lead judgment was written by Lord Justice Popplewell. Lord Justices Males and Underhill agreed with that decision. And Sadeq is our jumping off point for this talk because it's the Court of Appeal's most comprehensive restatement of legal professional privilege in recent years. Now, the underlying facts are relatively complicated and not really necessary to get into for the purposes of today. They're actually quite dramatic, but sort of in a nutshell. Mr. Sadeq was the former deputy CEO of a sovereign wealth fund of an emirate called RAK. RAK claimed it had been the victim of wide-ranging frauds of which Mr. Sadeq was said to be complicit in. Mr. Sadeq was arrested in Dubai. He's then extradited to the Emirates, where he was tried, convicted, and imprisoned. Dechert, the firm, and a number of its partners specifically, were engaged to assist in the investigation of the frauds. Mr. Sadeq brought proceedings against Dechert and some of its partners over the way they'd assisted in the investigation. He said, essentially in fundamental violation of his rights, and he made quite striking claims really against them. But following disclosure in those proceedings brought by Mr. Al-Sadeq, the firm withheld disclosure of certain documents on the grounds of privilege, which Mr. Al-Sadeq then challenged on various grounds, including those grounds which were sort of then elucidated within the decision which we'll be discussing today. The actual decision itself and the reasoning does not really matter because it's obviously very fact-specific to the facts of that case. What matters is that the Courts of Appeal use the opportunity to restate the core principles of legal professional privilege and clarify them in some areas. But before we get into all of that, as promised, a very brief recap of legal advice privilege and litigation privilege, quoting from the judgment in Al-Sadeq given by Lord Justice Popplewell. So legal advice privilege, as I'm sure you'll all know, applies to communications between a lawyer and its client for the sole or dominant purpose of giving or receiving legal advice and documents which would reveal the contents of such communications. Litigation privilege attaches to communications between a lawyer and its client or third parties which are brought into existence for the sole or dominant purpose of use, looks like a typo, but it's actually not, in the conduct of existing or contemplated adversarial litigation. Now, as we all know, those quite short definitions can cause a lot of consternation. For example, the sole or dominant purpose test, which applies to both types of privilege, and what amounts to contemplated adversarial litigation in the context of litigation privilege. But remember, when it's established, legal professional privilege is inviolate. There is no discretion in its application or not. As Lord Hoffman described it, it's a fundamental human right. What the iniquity exception is it says essentially privilege does not arise. So it never comes into existence in the first place in respect of documents which come into existence in relation to a fraud, crime, or other iniquity. And the key phrase is documents which come into existence in the course of or in furtherance of. Now you can see from the date of O'Rourke and Derbyshire, that's a long settled principle, certainly in relation to criminal acts and fraud. But the general trend of thinking following slightly more modern cases, such as Barclays Bank and Eustace, is that it's not just limited to criminal or dishonest acts. Iniquitous conduct can fall short of dishonesty. The touchstone that was stated in Al-Sadeq is put here. The touchstone in distinguishing such cases from those where the exception applies, where the iniquity exception applies, is whether the iniquity puts the conduct outside the normal scope of such professional engagement, i.e. professional engagement between lawyer and client, or as an abuse of the relationship which falls out within the ordinary course of such engagement. Perhaps it's better understood through understanding as well what it is not. And forgive me if this seems obvious, but it is not a rule, as I'm sure you'll appreciate, that documents relating to past misconduct, even if that conduct was criminal, fraudulent, dishonest, or plainly iniquitous, are not privileged. And the reason for that is probably obvious, in that the public policy rationale for LPP is to ensure that people can be full and frank with their lawyers and receive legal advice without fear of that communication being disclosed. And I've put a long quote from Al-Sadeq in the slide there, which I'm not going to read now, and I don't think you need to read now, but it puts what I've just said there slightly more judicially. And that quote is the direct run-in to the touchstone quote from the previous slides. That quote's talking about what's the ordinary run, the usual run of professional engagement, communication between lawyer and client, where client might be taking advice or seeking advice on what might amount to misconduct. You have to ask yourself, does this communication, does this advice being sought cross the line and amount to an abuse of that relationship, which otherwise would be protected by way of the law of privilege? So how might this all work in practice? Let's say we have an example where a company has lost a case and it owes a judgment sum of £10 million to the successful claimant company, and the claimant successful is therefore now a judgment creditor. Say the CEO of the company approaches its solicitors and says, we could really do with that £10 million for a planned investment. Is there anything we can do about this? Now, just pausing there, as framed, do you think that question is an abuse of the lawyer-client relationship? Now, I'm not good enough at Zoom to run any sort of poll here and now, but just take a moment to think on that for yourselves and what you think, and whether or not that, on the face of it to you, appears to be abuse of the relationship such that the iniquity exception could apply. So in respect to that, like any lawyer, I've said it depends, because obviously it does on the wider context. But my own take on that question as framed by the CEO there is that it's unlikely to amount to an abuse of the lawyer-client relationship, because, as I'm sure you'll appreciate, there are perfectly lawful and proper ways that something might be done about a £10 million judgment debt. I've given a few examples here. We don't know, for example, whether or not permission to appeal has been sought, and whether a stay of enforcement might be obtained in the meantime. It might be that enforcement could be delayed. Payment installments could be reached by way of negotiated settlement or some other means. But let's say the conversation progresses and the CEO then says something like, we have an offshore corporate shell in Cambodia. Could we transfer the £10 million there to put it beyond the reach of our judgment creditor? I've chosen Cambodia because I understand, obviously I've never tried, I understand it's near impossible to enforce foreign judgments there. Now, imagine for most of you, the alarm bells are now ringing as they should, not least if you've read the title to the slide. And that should be the case even if you know nothing about the Insolvency Act 1986, because what this clearly amounts to is the CEO trying to take advice on prospective asset sheltering. And advice on such a step would, I think, almost certainly amount to a transaction defrauding a creditor under Section 423 of the 1986 Act. And in any event, it was held in the very long-running and acrimonious oligarch divorce case or proceedings of Akhmedova and Akhmedov, that such a step would be iniquitous. So that's one example where it is clear, I think, that that would be an abuse of the lawyer-client relationship to take advice on such a step. There are more examples in the cases. It's probably often the case of, you know it when you see it, but that you can see there how you can have something which might start off as innocent and then maybe cross the line over into something that amounts to iniquity. What Sadeq clarified or restated, though, is the merits threshold, i.e. what is meant by establishing a prima facie case, the iniquity exception. And what the Court of Appeal said is that it's the balance of probabilities test. So it's not a lower test. It's not a real prospects of success. It's not a serious issue to be tried, not a good arguable case, or anything, other phrase that you sometimes see in other contexts, which might involve a degree of probability of less than 50%. So if you want to establish the iniquity exception, you're establishing that before the court with evidence that establishes it on the balance of probabilities. Lord Justice Popper said, save in exceptional circumstances. I don't really have time to go into what he meant by that now, but essentially he is saying that there might be some circumstances which he did not attempt to conceive of and did not apply in the present case of Sadeq, in which something more like a balance of harm exercise might be undertaken, such as those which you see applied to interim injunctions. But he essentially said it's going to be very undesirable to apply anything other than simple balance of probabilities test, and it's going to be very unlikely in a disclosure context. But he simply said it could arise, and he didn't want to rule it out. Of likely more practical relevance are issues of what sort of evidence might be needed to satisfy the court on the balance of probabilities. And I've given some suggestions here, including conveniently creating a fictional whistleblowing employee of the company who overheard the conversation between CEO and lawyer and reported it to the judgment creditor. The gold standard, clearly, would be something like a witness statement from them. Contemporaneous documents, well, of course, ideally, but again, save some sort of white knight whistleblowing employee. It's difficult to imagine what might realistically cross the line to the judgment creditor. Evidence of similar past conduct by the company, well, maybe from which inferences might be drawn, but unless the company has a serious track record of such conduct, it might seem unlikely on its own, but perhaps taken together with other things, that might be the sort of thing which would help to prove the case. Finally, on the iniquity exception, how far does it extend? Well, it's documents which report on or reveal the iniquitous conduct, or documents which come into existence after the iniquity is complete, if they refer back to advice or plans along those lines. So that is a very brief shot through the iniquity exception. So I hope you now at least know what it is and what perhaps to look for, etc. I now want to turn to, in the remaining time, legal advice privilege in an investigations context, to work through some features and the limits of it by way of some hypothetical scenarios. But before getting to those scenarios, there are 2 points I just want to provide a brief recap of to help explain. So the first comes from Three Rivers number 5, not to be confused with Three Rivers numbers 1 to 4 and 6. It's a relatively controversial decision, this one, and it has been criticised by the Court of Appeal, but they've nevertheless said that they are bound by it unless the Supreme Court has a look. What it says is, well, we know that legal advice privilege protects communications between a client and a lawyer for the purpose of taking or receiving legal advice, etc. Three Rivers, in a nutshell, says that in a corporate context, for LAP, when considering who the client is, it is only those authorised to communicate with the company's lawyers for the purpose of obtaining legal advice whose communications are privileged. Now, of importance, Sadeq confirmed that this principle does not apply to litigation privilege. That applies, as you saw from the definition earlier, to third parties as well. So in a corporate context, a third party for privilege purposes might be an employee of the corporation who is nevertheless not authorised to obtain legal advice. In a litigation context, communications between them is still covered by litigation privilege. But in summary, for legal advice privilege in a corporate context, you need to always ask yourself, is this a communication with the client? This second point to cover is how to view so-called multi-addressee communications, i.e. those between a lawyer and the client, but also addressed to or from other individual parties. The most common example of this is where a lawyer is copied in on emails, some of which might be privileged, some of which might not. And the most authoritative statement of principle comes from the Jet 2 case, which I put there, relatively recent Court of Appeal case decision again, where essentially the court laid down or set out a quite clear 2-stage test for looking at any communication. The first stage is to ask yourself, is the dominant purpose of this communication to seek or give legal advice? If yes, then it's clearly privileged. If not, nevertheless, you then need to go on and ask yourself, secondly, does this communication disclose, is it likely to disclose, or may it disclose the nature and content of the legal advice sought from or given by the lawyer? And if the answer to that is yes, then the communication is privileged. If not, then no, it's not privileged. So the headline from this is, as you will all know, you can't just copy a lawyer into a communication to make it privileged. But obviously it's a little bit more complex than that on a case-by-case basis. So on to the actual scenario. Let's imagine an employee in the finance department of a company who raises a complaint with the HR director, HR, saying that he's been bullied by a fellow employee, and HR then approaches the head of the finance department, FD, and the company secretary, CS, who is a qualified lawyer, to discuss the next steps. So we're going to work through some various example communications. They are deliberately, in some cases, borderline nuanced. I'll give you my views, but I think it's fair to say that reasonable people can disagree on some aspects of these. And I should know, because I've adopted and modified these scenarios from some that were discussed at an excellent Chancery Bar Association workshop, which I went to at the start of this year. And as I'm sure you can imagine, amongst a room full of barristers, including quite a number of silks, there really was some disagreements on some of these, but I hope they at least provide some food for thought. So scenario number one, we have an email from HR to CS. Recall CS is the company secretary, but also a qualified lawyer, and FD, setting out the proposals for how the matter should be investigated, asking for their comments on the procedure and their views on the reputational implications for the company if the matter becomes public. So first point to note, this probably is obvious in this point, context, we are not in litigation privilege territory. This is still just at the complaint stage, so we cannot say that proceedings are in reasonable contemplation. So we are in legal advice privilege territory, if anything. First question to ask yourself is HR, head of HR, authorised to obtain legal advice? Well, let's say probably yes, given their role and seniority, and frankly, to make my life easier in the rest of these scenarios. But always ask yourself that question at the outset. So applying the two-stage test from Jet 2, first, in my view, it's unlikely that the dominant purpose of this email is to obtain legal advice. It's addressed to both the CS, company secretary, and the FD, and seeks the advice and input of both on both procedure and PR implications. So on the first stage, no, I think it's not privileged because it's not the dominant purpose to seek legal advice. Nevertheless, on the second stage, does this email reveal something about the legal advice being sought? I think it's very unlikely here, unless it was to be worded very specifically, maybe along the lines of, CS, please specifically advise on the lawfulness of how the proposed process complies with our legal obligations under the grievance policy and under employment law, etc., etc. But again, on the face of it, I think it doesn't reveal something about the legal advice being sought, and so doesn't satisfy the second stage of Jet 2 either, and therefore is unlikely to be privileged on that test. There are just two further points to consider with a communication like this. CS is an in-house lawyer. We also know that she is the company secretary. So presumably, like many in-house lawyers, or some in-house lawyers at least, she may have a role that is wider than just being a legal advisor. So what hat is she wearing as the recipient of this communication? Legal or business advisor? If CS was an external solicitor, it's probably easier to satisfy that or answer that question at least, because although sometimes solicitors can be asked for and provide business input, although you're braver than me if you do so, generally they are receiving and sending communications as legal advisor. But with an in-house lawyer and with someone like a dual role at CS, they might be wearing two hats. The second point is, as I've put here, the request for PR advice, that itself is very unlikely to fall within the scope of anything like legal advice privilege. That's scenario number one. Scenario number two, FD replies to that email and says something like, this is called Med, Ed is an absolute nightmare. He's made up similar stuff in the past, and I think he's just making this up again. Points to consider. First, communication from the client, is it? Well, probably yes. The FD probably is likely authorised to seek advice given their seniority. So considering the two-stage Jet 2 test again, is the dominant purpose of this email to seek legal advice? A part of that consideration, we know from paragraph 100 of Jet 2, can be if the communication is in substance to settle instructions to the lawyer. So again, hypothetically, well, maybe say if HR's original email had also said something like, FD, please provide any input and background information to help CS advisors on this case. then perhaps an email of this sort, although probably not this email, could be something like something that in substance is setting instructions to the lawyer. But, and this is why I think on the face of this, the first stage is probably not met. This email appears unsolicited. In that regard, it expresses an opinion and quite strong views rather than providing facts, and does not in substance appear to be intended to inform any advice that CS may give. Second stage of Jet 2, does it reveal anything about the legal advice being sought? We don't really know. This, I think, I'm just using as an example of the sort of email which demonstrates that merely copying in a lawyer does not render a communication privileged. Scenario number 3. Now we have an email from HR to FD, note not copied to CS, saying something like, I've spoken to CS, she said that an investigation should be carried out and has told me who should be interviewed and the key questions that should be asked of each witness. The first point to note, which hopefully you will have all spotted, is that this is not a communication with a lawyer because CS is not copied in. But this is an example of an email which does constitute secondary evidence of a privileged communication, and so it itself attracts privilege. With the caveat, as ever, provided that the advice that CS was giving was being provided in her capacity of an in-house lawyer. But here, based on the content of the email, it's likely that that is the case. Fourth scenario, now we have an email from HR to CS, so between client and lawyer, reporting conversations that HR has had with Ed, in which Ed insisted that the alleged perpetrator of this bullying should be suspended pending the outcome of the investigation. So it's communication between lawyer and client. And again, considering the two-stage Jet 2 test, although it's not expressly seeking legal advice, so the dominant purpose doesn't appear to be to seek legal advice, this email, or an email of this type, probably falls within what's described as the continuum of communications between a client and lawyer, which themselves are protected by legal advice privilege. And that continuum of communications principle is described very clearly in Three Rivers number 6, House of Lords decision, and comes from the Belabel case there. So as part of that often chain of emails or continuum of some form of communication, this email itself does likely attract LAP. Final scenario for today. So this is CS's final report on the complaint, which also attaches interview notes with the junior employees interviewed. So we need to consider this in two parts. First, the report. Well, that's easy, I think. That's covered by legal advice privilege. It's produced for the dominant purpose of advising HR and FD and anyone else in the company on the complaint. But what about the interview notes? Well, I deliberately used the word junior employees, which has hopefully made you think, why has he used that word? Well, recall that the client issue from Three Rivers number 5, because these are communications between junior employees, so those unlikely to be authorized to obtain legal advice, they're probably not covered communications which would be covered by legal advice privilege on the face of Three Rivers number 5. Certainly interview notes, certainly if they're the verbatim transcripts as communications. Three Rivers number 5 says not covered by LAP. So the interview notes appended separately to the report, likely not covered. Now, this all gets a bit nuanced, as ever, because as some of you may know from practice, there is a doctrine, sometimes called the lawyer's working papers doctrine, which says that if notes, like notes of interviews or commentary on interviews, if they're not simply verbatim transcripts of interviews, betray the tenor of the legal advice being given, then those notes would potentially attract privilege. that comes from, well, that was argument that was ran in the RBS like rights issue litigation case there. But it should be noted that RBS ran that unsuccessfully. But what is sometimes done in practice is the lawyer might mark up or add comments to their interview notes, perhaps in a sidebar saying something like, notes, this evidence is consistent with the evidence of the employee number 4, therefore corroborative and lends credibility to our defence. Perhaps in a bid to make everything privileged, or that to make certainly that part privileged. But what I'm sure you will appreciate, the far more likely outcome is that rather than the entirety of such notes being redacted or being argued to be privileged, the note itself, if that was a note with a verbatim transcript, would be redacted rather than the entire document. And the final thought I'm going to leave you on today, having worked through those and that fairly brief trot through, imagine if one of the interviewees had in fact been FD, i.e. not a junior employee, and someone who could constitute the client. For those notes of that interview, there would be an argument to say that they should be privileged. But it should be said that quite often the view is taken that all fact-finding in the context of a corporate investigation is not privileged. And so that those notes, even of someone like the client in that context, would not attract LAP. Bit of a grey area, that one, and something to leave you on to mull over perhaps. So thank you all very much for attending. I'm afraid we've run out of time and indeed gone over time for any questions, but I have put my email there. So any questions you may have had, please genuinely do feel free to drop me a quick email and I'll try and send you a fairly quick reply. You'll probably get a fairly more considered answer from me that way anyway. But like I say, thank you all very, very much for attending. I appreciate your time. And apologies we've run slightly over, but I hope that was of some use, interest, and at least perhaps was food for thought. So thank you. I'll end the seminar now. We'll circulate slides, be recording me available, and hopefully see you all soon. All right. Thank you very much. Goodbye.